Good afternoon. My name is Philip Hundle. My practice area focuses on landowner condemnation. I represent landowners. Something I'd like to talk about today is when there's a possible pipeline or power line coming through your property, and the pipeline company or condemner sends out a right-of-way agent on behalf of a survey crew to get permission to go on your property, begin to conduct a survey, other preliminary investigations regarding whether maybe they'll soil samples, whether they'll bore a creek, archaeological or cultural surveys to determine if there's any evidence of any historical or archaeological sites on the property. Any of that type of work, typically a landowner is going to be approached by a right-of-way agent that's requesting entry onto the property. The pipeline company will try to get the landowners to sign without much thought, actually, on the landowner's part about this survey, quote-unquote, permit or agreement. And so I'd like to talk about that. Several ways that the pipeline company will attempt to get a right to enter your property. A lot of times they'll get verbal permission, and therefore they'll say the landowner gives verbal permission and they enter the property. They may enter the property on weekends, odd hours that aren't convenient to the landowner. We try to cooperate with the pipeline companies. And I'm saying pipeline company, it could be a power line company, it could be a water line, but any type of condemnation project. We try to cooperate with the condemner as much as we can in the beginning to allow the survey crew to come on the property and do what they need to do. However, not damage the property, not interfere with the landowner's existing or current activities on the property, be it hunting, be it farming, ranching, whatnot. So what we would like to do, and normally what we do in our temporary access entry agreements is, number one, it's temporary. Next, we have a notice requirement if there's going to be a survey crew coming out on the property, that please give the landowner some notice, typically 24 hours, 48 hours, 72 hours, whatever the landowner thinks that they need. Also, when the survey crew's out there, if they would, and oftentimes they do this, but if they would mark the center line of the easement, the proposed easement, and then also mark any temporary work areas that they're also attempting to acquire in the condemnation process. That allows the landowner to get a better feel for what this at least initial proposed route will look like and the impact on his property and improvements, and just get a better feel for where this actual route may run. How many trees are going to be affected, what fence lines, and then also exactly if there's creeks or rivers on the property, how those will be crossed. So we like to make it temporary. We don't want it open-ended, that survey crews can enter the property for the life of the project or who knows how long. So we try to make it temporary, and we also like to limit the amount of area that the survey crew can enter and go on to. There's no need for a survey crew to run all around the property, the different extremities of the property, but limit their entry and access and their activity on the property to the proposed easement area. Also, we ask that in this particular case, in my example, I'm saying a pipeline company. The pipeline company provide the surveys and information gathered by the survey crews to the landowner sooner rather than later. Normally we have a time frame that both parties can agree upon. And that way the information that the pipeline company in the end will need to provide to the landowner gets to get that information a little bit sooner, a little bit earlier, and that will help with better knowledge of the whole project. Something that we address in the temporary access agreement is also damages. If something's damaged while the survey crew's on the property by the survey crew, then clearly the pipeline company will be responsible for that. So Some things to keep in mind, beware of these proposed survey permits or access agreements. Make sure that they're reviewed by a knowledgeable attorney who deals with condemnation issues for landowners.